In civil litigation, a winning substantive legal argument is worthless if a procedural deadline is missed. Blown timelines don't just delay a case, they can terminate a party's right to defend themselves. The 2019 amended Rules of Civil Procedure shattered the old culture of judicial leniency, replacing indefinite delays with strict front-loaded efficiency. Rule 11 provides the specific calendar day sequences for every defensive move. It establishes the exact moments when a party must respond or face an order of default. Mastering this sequence is the baseline requirement for survival in the highest courts of the Philippines. This sequence begins with Section 1. A defendant is granted exactly 30 calendar days to file their initial answer to a complaint. This 30-day clock is strictly triggered by the service of summons, not the date the complaint was originally filed. Section 2 adjusts this timeline for foreign private juridical entities to account for the logistical delays of international document transmission. If a foreign corporation is served through a designated government official, such as the SEC, the time to file an answer doubles to 60 calendar days from the moment that entity receives the summons. The initial defense timeline is dictated by the legal status of the defendant and the specific method of service. Under Section 3, if a plaintiff alters their complaint, the defense response timeline splits into two paths based on the nature of that amendment. If the amendment is a matter of right, occurring before a responsive pleading, the defendant has 30 days to answer. However, if it requires leave of court because an answer was already submitted, the defense has only 15 days. If a defendant chooses not to file a new response, the rules provide that their original answer automatically stands against the amended complaint. When the court formally permits an amendment, the procedural clock accelerates. Section 4 governs counterclaims and cross-claims, demands for relief filed by existing parties against one another within the same lawsuit. Internal claims require an answer within 20 days from service, the CC-20 rule. Section 5 handles third-party complaints, bringing a stranger into the litigation. Since they are sued for the first time, they receive the original 30-day preparation period, the T30 sequence. The rules scale preparation time based on how much prior exposure a party has had to the ongoing case. Before 2019, plaintiffs often filed a reply simply to deny the new matters in an answer. Section 6 restricted this by stating that all new matters in the answer are now automatically deemed controverted. Filing a reply is now forbidden and will be expunged unless the defending party attached an actionable document, like a contract, to their answer. Only then is a reply permitted, with a filing deadline of 15 calendar days. Section 7 governs supplemental complaints, which are filed to introduce relevant facts that occurred after the initial litigation was underway. These require an answer within 20 calendar days from the notice of the order admitting the supplemental pleading. The current rules favor short, strict deadlines whenever new evidence or parties are introduced to the record. Sections 8, 9, and 10 prevent the filing of multiple disjointed lawsuits by requiring parties to bring all related claims at once. Under Section 8, a compulsory counterclaim must be set up in the answer. If not included at that moment, the claim is barred forever. Section 9 allows for claims that mature after the answer is filed, which can be introduced through a supplemental pleading if the court approves. If a pleader accidentally omits an existing claim, Section 10 allows them to seek an amendment to include it, provided the case is still ongoing. Failing to audit your own claims when drafting the answer results in the permanent loss of the right to recover those damages. Section 11 is the most rigid of the 2019 amendments, designed to stop lawyers from asking for repeated time extensions. The rules strictly prohibit motions for time extensions for any pleading other than an answer. Such motions are mere scraps of paper. A defendant is allowed exactly one motion for extension, strictly limited to 30 days, exclusively for the answer. Filing an unauthorized motion for extension does not pause the timeline. The period will expire, the pleading will be rejected, and the party will be declared in default. Section 11 establishes a hardline countdown that the court will not waive. Rule 11 is a set of interlocking deadlines designed to force the case toward a final resolution. Every day count is a specific procedural requirement. The 2019 system established a trade-off. Defendants received longer initial preparation times for the answer, but the court now has zero tolerance for subsequent delays. To succeed under these rules, you must lock in trigger events and memorize procedural timelines. Beyond the singular 30-day extension for an answer, procedure is absolute.